So what the court is saying is, if you have infringement occur on your home network without anyone knowing who committed the infringement, how do we know the defendant, infringer, is actually in your state, is actually in your region, and we've got the right court system here? This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. So we've had a lot of questions over the past several years about whether an IP address can be traced to a person and what legal procedures are allowed to be used and how much evidence has to be presented before you're allowed to trace that IP address through a subscriber to, say, a copyright infringer. Well, this is another one of those where a copyright quote troll, quoting Judge Royce C. Lamberth, because calling someone a copyright troll could be considered defamation, and Strike 3 Holdings has not been proven to be an illegal copyright troll. I would like to think that they are, but I can't prove it yet, and I would like to have a client come along that is willing to work with me, and even we can hire a whole team of people to try and prove that Strike 3 Holdings is conducting its cases illegally, because they've filed over 3,000 cases over the last 2+ years, and they're all over this BitTorrent-based copyright infringement. They have an alleged investigator in Germany who has a sort of shell company in the US, and they purport to watch BitTorrent swarms or BitTorrent networks and become one of the peers, and then monitor and log and then sue everybody who's allegedly downloading their material. Well, all of that sounds pretty interesting, and in my defense attorney opinion, pretty shady, because there's a lot of places in there where maybe none of that error checking was done. I'd like to see, Six Sigma error checking done every step along that way, and they've basically alleged only one level of error checking along the way, barely a second check on things. So let's take a look at what this judge in the Southern District of Florida has to say about Strike 3 Holdings' request for a John Doe's identity. This causes before the court upon plaintiff's motion for leave to serve a third-party subpoena prior to a Rule 26F conference. All of that is just code for we're out of order, where we're before the person has been served, so we can't do any discovery till we have service. So that's what they ask for permission for. The court has reviewed the pertinent portions of the record and is otherwise fully advised. In the instant motion, plaintiff seeks leave to serve, is it Kajiko Communications, an internet service provider, with a subpoena pursuant to Federal Rule Civil Procedure 45 in order to obtain the identifying information for the subscriber assigned with a specific internet protocol address. The court ordered plaintiff to show good cause as to why the court may reasonably rely on plaintiff's usage of geolocation or other technologies to establish, 1, the identity of the defendant, and 2, that the defendant may be found within this district. This is important. The court has used the defendant language, not subscriber. So what the court is saying is, if you have infringement occur on your home network without anyone knowing who committed the infringement, how do we know the defendant, infringer, is actually in your state, is actually in your region, and we've got the right court system here? That's what we're asking. You could think of ways that the person might not even be a resident of the state. They might be passing through. They might have been staying the night or something. On April 23rd, 2019, just last month, plaintiff filed its response to the court's order. Plaintiff has shown that the geolocation software can provide a location for an infringing IP address. However, other than stating that it is plausible that plaintiff could identify the infringer via his or her IP address, plaintiff has not shown how this geolocation software can identify the defendant or that he or she may be found in this district, and therefore plaintiff has not shown good cause as to why this case should not be dismissed for improper venue. There is nothing that links the IP address location to the identity of the person actually downloading and viewing plaintiff's videos, and establishing whether that person lives in this district. For example, it is entirely possible that the IP address belongs to a coffee shop or open Wi-Fi network, which the alleged infringer briefly used on a visit to Miami. Even if the IP address were located within a residence in this district, the geolocation software can identify who has access to that residence's computer and who allegedly used it to infringe plaintiff's copyright. It is no more likely that the subscriber to an IP address carried out a particular computer function, here the purported illegal downloading of a single pornographic film, than to say an individual who pays the telephone bill made a specific telephone call. Plaintiff makes much of the fact that many courts in this circuit have permitted this limited discovery to confirm venue. But several courts have found it troubling that the subscriber associated with a given IP address may not be the person responsible for conduct traceable to that IP address. And there's some citations here. And some courts have adopted the view that an IP address is not or may not be a sufficient basis on which a plausible claim can lie against a subscriber. Thus, the court finds that plaintiff has not established good cause for the court to reasonably rely on plaintiff's usage of geolocation to establish the identity of the defendant. The court also finds that plaintiff has not established good cause as to why this case should not be dismissed for improper venue. Ordered and adjudged this 7th day of May, and this is Ursula Ungaro, United States District Court for the Southern District of California. So that's good. I've made that exact argument before, both in the Eastern District of Pennsylvania and the Eastern District of Virginia, and the judge did not agree that the geolocation technology was insufficient. The judge also did not agree with many of the other arguments about an IP address not being a person, subscriber not necessarily being defendant. The courts are pretty split on whether Strike 3 holdings and the like are allowed to subpoena a John Doe subscriber's identity in order to fish for a John Doe defendant's identity. And that's also not the way they phrase their motions for the subpoenas prior to the Rule 26F conference. Those pre-discovery or what we call expedited subpoenas. They don't phrase it that way. They phrase it as if subscriber is defendant, as if the infringer is automatically the subscriber, or the subscriber is automatically the infringer. And the courts, Eastern District of Virginia and Eastern District of Pennsylvania, very intelligent courts that I respect. Judge Smith, a very respectable judge. Nothing wrong with him. I'm not at all upset with Judge Smith's judgment. Just that I disagree with it. Just that I don't believe that there has been enough of a connection made between the infringement and the infringer to go through an innocent subscriber, and that they need to have more than that. They need to know and show something about the infringer in order to get the right to go through the subscriber. They don't even know if subscriber is infringer or not. They're just guessing and hoping that there's a significant period of time or significant number of statistical hits where the infringer turns out to be the subscriber. So I would like to see that become, that level of scrutiny be something that judges apply more often. However, I can't deny that there are lots and lots and lots of defendants that call yours truly because this is an anomaly. And judges don't typically rule this way, and so people do need legal representation. And what I try to do is offer legal representation for a flat rate that is affordable for my client and helps them judge how much risk and cost is going to be involved with the matter. When we litigate, I don't charge flat rates, which I guess is also why we don't litigate as often. I would like to litigate these cases more often, and I would like to argue the finer points of copyright law on these cases, but unfortunately the judges in my area and many judges nationwide don't agree with Judge Ungaro here. Also, I guess I can add, if you have been the recipient of one of the letters or notices that are sent out in one of these Strike 3 Holdings or Malibu Media cases, or anything BitTorrent based. I have a ton of experience with this. It's almost a sad level of experience. Sad in the sense that the court system has let it get to the level that I've literally represented 800 clients in these kinds of cases, is how many thousands of cases there are. Thank you very much to our May 2019 supporters at the $50 level. Thank you very much to John Steele, Gavin Barnard, Eevi, Andy, Kyle Mudrak, Verement, Tayne, Michael Pearce, Terry Crisp, Richard Fournier, Spirit Bear, Jan Negrey, Daniel Perez, Snorre Wisotzky, allquixotic, and Aspernari. Thank you very much for your support, and thank you very much to the $5 plus supporters who are scrolling on the LED panel behind me. And there you go, $5 plus supporters right there. And we'll be scrolling on the crawl at the end of this video. So love you all. Happy Mother's Day to all you mothers out there. I don't know what else to say. We love and appreciate you mothers. I love and appreciate my mother. Wouldn't be the guy I am without her. Anyway, love you all. Bye.